This module focuses on the proposed changes to the Rule on Provisional Measures, the new Rule on Security for Costs, and the provision on stay of enforcement of an award in post-award remedy proceedings.
In each of these procedures, a party is seeking some form of interim relief during the proceeding, due to the particular circumstances of the case.
The current Rule on Provisional Measures indicates that its purpose is to preserve a party's rights, either procedural or substantive. The proposed rule provides a non-exhaustive list of provisional measures that a party may request from a tribunal. It includes preventing actions that would cause imminent harm or prejudice to the process, maintaining or restoring status quo, and preserving evidence relevant to the arbitration. This list is consistent with existing practice and mirrors the UNCITRAL arbitration rules. The proposed rule also specifies two conditions that have uniformly been required to grant provisional measures. 1, the measures must be necessary, and 2, the measures must be urgent. In addition, tribunals must consider all circumstances of the case.
The Secretariat does not propose to introduce emergency provisional measures, as this procedure is not always fit for investor-state disputes. Another form of interim relief, security for costs, is now specifically provided for in a separate rule. Security for costs addresses the risk that a party, typically the claimant, does not comply with a costs award rendered against it.
If the tribunal grants security for costs, the tribunal will order the party to deposit funds in an escrow account or provide some other type of financial security. This type of order must bear a consequence to be effective. The proposed rule provides that the tribunal may suspend and eventually discontinue the proceeding after 90 days if the party fails to comply with the order.
Most tribunals dealing with security for costs have ruled that they would only grant security in exceptional circumstances. Insufficient funds to cover the cost of the proceeding was a condition but was not enough. The tribunal looked at other circumstances. For example, whether the party had a record of non-compliance. The proposed rule does not specify the other circumstances, including whether a party has third-party funding, and leaves that for the tribunal to decide.
The Secretariat also proposes changes to the Rule on stay of enforcement of an award in post-award remedy proceedings. The rule codifies existing practice that a tribunal or committee may impose conditions for the stay, considering all relevant circumstances. This could be a written undertaking by the party that owes sums under the award that it will comply with the award following the post-award remedy proceeding, if the award is not annulled.
The rules also propose a clear procedure for all three forms of interim relief. The three types of requests must include all submissions specifying the circumstances that require the measure, irrespective of the timing when the request is filed, before or after tribunal or committee constitution. As soon as the request is filed, the tribunal or committee, or the Secretary General if the request is filed before constitution, fixes time limits for submissions on the request. The parties then file their written submissions, and there is sometimes also a hearing on the request. The proposed rule also includes the timing of the tribunal's or committee's decision on the request, which should be issued within 30 days unless there are special circumstances that justify the extension of that period.
The Secretariat's goal is to make the procedure clear and efficient while safeguarding the parties' rights.
For more information, see the ICSID website's Rule Amendments page, which is available in English, French, and Spanish.